Hello and welcome to our Stowe Talks How To series. I'm Joanna Newton, a partner at Stowe Family Law, and in this video we will look at how to apply for and obtain a clean break order. A clean break order is a type of financial order that is issued following a divorce or dissolution and, as the name suggests, it provides a clean break in terms of your finances between you and your ex-spouse. A clean break is a type of financial settlement that dismisses any future financial claims parties may make against the other. It therefore enables both parties to move forward and to be financially independent of one another. In terms of who can apply, it is open for either spouse to apply for a clean break order. A clean break order is issued by the court and severs all financial ties between you and your spouse. A clean break order is particularly useful, therefore, for those who don't have many assets to divide. A consent order, however, is a document that formally records any financial agreement reached between both parties. A consent order can include a clean break clause, meaning it functions in much the same way as a clean break order. A consent order, however, will record all, if any, obligations between the parties, to include ongoing maintenance, deal with properties, and potentially any pension sharing orders. The short answer is no. You do not necessarily need both parties' agreement to secure a clean break order. However, if you do not agree that there should be a clean break order, then you will need to apply to the court for an order without your spouse's consent. Obtaining a clean break order without the other party's consent will require the court, however, to make a determination, and in most cases, a clean break agreement can be made between the separating spouses themselves. A clean break order is important because if you do not get a clean break order, your ex-spouse is within their rights to make a financial claim against you at any point in the future. This means that they can request further financial assistance from you, regardless of whether you have been divorced for 1 year or 20 years. For example, if you were to win the lottery or you were to receive an inheritance, then there is a risk that your ex-spouse could make a claim against you, and vice versa. You could make a claim against them. You get a clean break financial order at any point after your conditional order for divorce or dissolution has been issued. You will need to have agreed on how your matrimonial assets will be separated, and the court will need to approve the terms of your financial separation before issuing the clean break order. How much a clean break order costs will depend upon your situation. If an agreement can be reached between the parties before solicitors are approached to prepare the necessary documentations, then the costs will be lower. If, however, solicitors are involved in financial disclosure and/or negotiating the financial settlement, which results in an agreement that there should be a clean break order, or if the parties cannot reach an agreement and the court needs to make a determination, then the costs will increase. If a clean break order is reached by consent, then there is a court fee of £53 in addition to any other fees, such as solicitors' fees that you may incur. Unfortunately, there is no set time frame, but it can take several months. If you can reach a clean break agreement amicably with your ex-spouse, then this will typically be much quicker than if you need to apply to the court to decide the matter. Therefore, how long it takes to get a clean break order will depend upon how quickly you can agree the terms of your financial settlement and/or how long it takes the court to process your application. A clean break order is meant to be a permanent solution, save there are some circumstances where you can look to revisit a clean break order. The intention behind a clean break order, however, is that it provides finality, completely severing all financial connections between you and your ex-spouse. There are limited circumstances in which a clean break order can be overturned, and these include circumstances where there is a very significant and completely unforeseeable change in circumstances soon after the order is made, or there is evidence of mistake or fraud. For example, one party fails to properly disclose assets during the divorce or settlement process. If you wish to have a clean break order overturned, then it is important to seek specialist advice early on to find out whether this may be possible. No, there are some circumstances where parties will have an ongoing financial commitment to the other, and it may not be able to achieve a clean break order. For example, and usually after a very long marriage, if there is a considerable discrepancy in incomes, then the court may consider making a spousal maintenance order. The court can also defer a clean break on capital and inheritance as well, and can do so if there is a maintenance order until that maintenance order itself has expired. It is important to note the court needs only to consider if a clean break is suitable in the circumstances and is under no obligation to make one. The importance of legal advice. It is important to speak to a family lawyer as your divorce or dissolution only deals with ending the marriage or civil partnership. It does not end the financial obligations between you and your spouse. It is very important, therefore, that as well as ending the marriage, civil partnership, you deal with any financial obligations as well. As explained, you do have the ability to sever all of those financial obligations remaining after a divorce or dissolution with a clean break court order, or alternatively, a consent order if the two parties can reach an agreement, or, if not, following court proceedings. Solicitors can assist with all aspects of resolving financial issues, from preparing the consent order, helping to negotiate the terms of financial settlement, or to ensure that you are represented within contested financial remedy proceedings. For more Stowe Talks, how-to videos and further free resources, visit stowefamilylaw.co.uk/support.